What makes this moment so powerful is not simply that a decision was handed down, it's that the decision didn't arrive quietly or symbolically. It arrived with force, with immediacy, and with consequences that stepped straight into the daily lives of roughly 600,000 Americans. Too often, we talk about court rulings as if they live in distant chambers or dusty legal books, disconnected from everyday reality. But this ruling proves something very different. It demonstrates that constitutional interpretation is not an abstract exercise. It is a living action that can redraw the boundaries of protection, eligibility, and opportunity in an instant. For hundreds of thousands of people, this was not a future concern or a theoretical debate. The impact was immediate. The moment the ruling took effect, the legal landscape shifted beneath their feet. Families woke up to new uncertainty. Workers faced questions about stability. Communities began reassessing what protections or pathways now exist or no longer do. And while policy debates often stretch over months or years, this decision condensed change into a single moment, reminding us how quickly law can transform lived experience. This is where the real weight of the ruling sits, not in legal terminology, but in human consequence. When we talk about enforcement standards, eligibility frameworks, or federal protections, we are ultimately talking about people making decisions about their futures, a parent deciding whether to stay in a job, a young adult wondering what opportunities remain open, a household calculating risk and stability. Legal interpretation becomes personal the moment it affects those choices. And what's striking here is the speed of that transformation. There was no gradual rollout, no long adjustment period. The ruling did what constitutional decisions often do at their most consequential. It recalibrated reality instantly. Systems that once operated under one interpretation must now function under another. Agencies adjust. Courts respond. Individuals adapt. This rapid shift highlights the immense power embedded in judicial authority. Power that doesn't merely suggest change, but activates it. We also have to recognize the emotional dimension of that immediacy. Change delivered overnight creates a sense of urgency that extends beyond paperwork or policy. It creates conversations at kitchen tables. It sparks calls between friends and colleagues. It fuels debates about fairness, intent, and the role of law in shaping society. For those directly affected, the ruling is not just news, it becomes part of their personal timeline, a before and after marker that influences decisions from this point forward. At the same time, this moment underscores a broader truth about how law operates in a complex nation. Legal frameworks are not static shields. They are interpretations continuously tested by new circumstances. When a ruling lands with this kind of reach, it forces institutions and individuals alike to reassess assumptions. What protections are guaranteed? What authority governs them? And how should citizens navigate a system that can pivot so dramatically? There's also a civic lesson embedded here. Decisions of this magnitude remind us that governance is not distant or abstract. It is active and ongoing. Mechanisms of interpretation, enforcement, and compliance ripple outward through workplaces, schools, neighborhoods, and public discourse. Even those not directly affected feel the secondary effects: economic shifts, administrative changes, and social conversations that influence the broader environment. Importantly, moments like this challenge us to move beyond passive observation. Understanding the ruling's impact means recognizing that law is not a spectator sport. It demands awareness, engagement, and a willingness to grapple with complexity, whether one views the decision as necessary correction or disruptive change. Its immediacy forces a collective reckoning with how legal authority shapes national direction. And perhaps the most profound takeaway is this: rulings do not wait for society to feel ready. They act, and society responds. That dynamic, decisive interpretation followed by real-world adaptation is part of the constitutional rhythm. It's how institutions evolve, how debates sharpen, and how citizens learn, sometimes abruptly, that the structure governing their lives is not fixed, but actively interpreted. For the 600,000 Americans standing closest to this decision, the drilling is not an academic milestone. It is a present tense reality. It informs what they can do today, what they must reconsider tomorrow, and how they plan for the future. That immediacy gives the moment its gravity and its urgency. It reminds all of us that when constitutional interpretation shifts, it does not do so quietly. It steps directly into people's lives and demands a response. What also makes this moment impossible to ignore is not just what the ruling changed, but how it was decided. The 6-3 split is more than a numerical outcome. It's a window into a deep and ongoing debate about how the law should be read, applied, and evolved. Decisions like this remind us that the judicial process is not mechanical. It is shaped by interpretation, philosophy, and competing visions of how authority should function in a constitutional system. And when that divide is this clear, it signals that the conversation surrounding this issue is far from settled. At its core, a divided ruling reflects differing answers to foundational questions. How much discretion should institutions have? Where do statutory boundaries begin and end? How should precedent guide present decisions? These are not abstract puzzles reserved for legal scholars. They influence how governance operates in real time, when a majority interprets the law one way and a dissent sees it differently. We are witnessing the living tension that defines a dynamic legal system, one that evolves through debate rather than uniform agreement. This kind of split also tells us something important about trajectory. Judicial divisions often foreshadow continued litigation, legislative responses, and administrative recalibration. A close vote doesn't end discussion, it energizes it. Advocates study the reasoning. Policymakers evaluate the implications. Future cases begin forming around the edges of the decision. The ruling becomes less of a final chapter and more of a pivot point. A moment that reshapes strategy, argument, and expectations moving forward. For the public, this visible divide can feel unsettling, but it is also a sign of institutional vitality. A legal system that accommodates disagreement is one that recognizes complexity. The issues reaching the highest levels of review are rarely simple, and the presence of dissent demonstrates that multiple interpretations can exist within the same constitutional framework. That tension is not weakness. It is part of how legal boundaries are tested, clarified, and sometimes redefined. There's another layer to this division, one that touches on public trust and civic perception. When people see a split decision, they are reminded that law is interpreted by human minds grappling with evolving realities. That awareness can spark debate about fairness, intent, and institutional role. It can also encourage deeper engagement, prompting citizens to follow how legal reasoning shapes policy outcomes. In that sense, a divided ruling acts as a catalyst for civic conversation, pushing legal issues into the broader national dialogue. Importantly, such divisions also influence how future disputes are framed. Legal arguments do not emerge in isolation. They respond to prior reasoning. A strong dissent today can become the foundation for tomorrow's majority. Just as a narrow majority can invite refinement in later cases, the ripple effect is cumulative. Each split decision becomes part of an ongoing dialogue across time, guiding how courts, lawmakers, and agencies interpret authority and responsibility. We should also consider how this judicial divide intersects with policymaking. When courts deliver decisions with significant societal impact, lawmakers often respond by clarifying statutes, adjusting frameworks, or proposing reforms. That interaction between branches is not accidental. It is built into the structure of governance. A divided ruling can sharpen legislative focus, highlighting areas where ambiguity exists and where democratic processes may step in to provide direction. On a practical level, this split signals that institutions and individuals alike should expect continued legal landscapes shaped by divided decisions tend to remain active spaces of interpretation. Regulations may be revisited, enforcement standards may adapt, advocacy efforts may intensify. The ruling becomes a reference point in a broader continuum rather than a static endpoint. What matters most is recognizing that disagreement within a legal institution does not paralyze progress. It channels Italiano. The presence of multiple judicial Philosophies ensures that decisions are stress-tested from different angles. That process can be messy, but it is essential to maintaining a system capable of responding to change without losing coherence. The debate, embedded in a 6-3 ruling, reflects the balancing act at the heart of constitutional governance, preserving stability while allowing interpretation to evolve. For those watching closely, this moment is a reminder that the law is shaped not just by outcomes, but by reasoning. Understanding the divide encourages a more nuanced view of how authority is exercised and how precedent is built. It invites citizens to look beyond headlines and into the underlying principles guiding decisions that affect national direction. And perhaps the most enduring lesson is this: a divided ruling does not close the conversation. It defines the next phase of it. It signals that the questi